I'd like to begin by asking a question. Is there any justifiable reason to have three male European arbitrators in a dispute between a Chinese investor and an African state? So the topic of my presentation is the unique challenges that least developed countries face in getting the composition of the tribunal right. The investor-state dispute settlement system has in recent years attracted acrimonious criticism, not only because of allegations of pervasive conflict of interest and inconsistent jurisprudence, but also because of evident representational deficit. Developing countries dread the arbitral process, principally because they are called upon to answer charges of violations of indeterminate external standards before a group of total strangers, not a jury of their peers. They are frequently concerned that the arbitrators are not only biased against them, but more importantly, they fear that the arbitrators are often incapable of understanding them because of their cultural background. They know that in the arbitral process, the three people who make the decision are not necessarily the most informed three people in the room. In most cases, the parties and their counsel know exactly what happened between the parties, but they present evidence selectively, not necessarily to aid the arbitrators to arrive at a correct result, but to distort their vision and steer them in a particular direction. In the words of Judge Jerome Frank, in the adversarial trial, what the lawyer does is the equivalent of throwing pepper in the eyes of a surgeon who is performing an operation. Arbitrators apparently have developed that culture. Specialists who represent the parties. But it's very common knowledge, I would say, that any decision-making body improves the quality of justice by diversifying who is in that jury pool. Both the New York Convention and the ICSID Convention were actively promoted to developing countries with the promise that they would be helpful to modernize their laws and attract investment. The New York Convention was promoted by the United Nations, and the ICSID Convention was promoted by the World Bank. The United Nations had committed to assisting developing countries to acquire and develop expertise in this area. And indeed, the record shows that it was anticipated that such expertise would be developed within a relatively short period of time. I was looking at the history of the making of the New York Convention, and there was that promise. The United Nations relegated this task to the Chambers of Commerce in Europe, resulting in the effective outsourcing of the administration of international economic justice to European capitals. At the most basic level, the ICSID Convention permitted developing countries to designate arbitrators who are not their citizens. They naturally relied on experts from the developed world. In most cases, they appointed arbitrators they neither knew nor understood. 50 years later, they continue to do the same because their citizens are still said to lack the required expertise. For more than half a century, they appeared before ICSID tribunals in large numbers and answered charges of expropriation and denial of justice, among others, before a limited and mostly Western arbitrators. Regrettably, in investment arbitration, the composition of arbitrators today looks a lot like it looked like 50 years ago. If you look at the composition of the tribunals for all of 22 investor-state arbitration against India, most of them are Western arbitrators. The most recently published ICSID statistics shows that while cases against sub-Saharan Africans constitute about 15%, only 2% of arbitrators have been African. Evidently, without irony, developing countries still face the exact same dilemma that it faced 50 years ago. The problem is broader than the alleged lack of expertise in the developing countries. It is a function of the world's economic decision-making hierarchy. The pool of arbitrators is structurally kept small. This is not pure theory. Those of us who represent developing countries know it's very well that this is structurally embedded in the whole system. And I mentioned a few examples. In bilateral investment treaties, developing countries often say whether it's ICSID arbitration or UNCITRAL arbitration, the key appointment authority, the default appointment authority, goes to the chair of the Administrative Council or just Secretary General of the PCA. In those authorities exercise their appointment authority in such a way that they avoid the risk. The easiest thing to do would be to look at the familiar list and appoint people from that. And in the last 50 years, they have not helped the diversification of the arbitral pool. So what must developing countries do when they are confronted with a case? The first thing that they see is the private investor obviously nominates someone who is very well known and frequently leads to a certain very limited pool. And then, of course, the developing country is confronted with the challenge of who should I appoint? If they appoint someone they know from their own country or someone from a very familiar list, they are afraid that the best they could hope for is probably a very good dissenting opinion. But the question of getting the arbitrators right does not have a very simple solution. The solution lies in the diversification of the pool. And studies in the United States, jury studies in the United States suggest that a diverse group of jurors is most likely to get the result right. Not because of just because they are diverse, but because they represent and they educate each other, bring different perspectives. And I'm rushing through this because of the time constraints. So I think the final thing that I'd like to say is respondent states must reject what I call the mythology of specialized knowledge. The reason that keeps the number of arbitrators extremely limited is because there is this mythology that only a limited number of individuals can resolve the world's investment disputes. And my message is, try Justice Stevens. I don't believe he has acted as an arbitrator, and have him as a chair and see how he does. And try someone from the Court of Justice of Comesa and see how they do. And my message is this. As Professor John Crook says, the arbitral process is a very simple and straightforward one. It involves 3 steps: the ascertainment of the applicable rules of law, the determination of fact, and the application of those facts to the law. Learned jurists everywhere in the world do that. There is nothing particularly sophisticated, particularly challenging, that it would exclude the world's jurists across the board from serving as arbitrators. The fact that they don't have an arbitration experience must not be a barrier to those who are capable otherwise to serve as arbitrators. Thank you.
Thank you very much, Professor Kindane.